You are, to my knowledge, in fact, the first congressional committee in decades and perhaps ever to ever directly focus on this privilege. The privilege is routinely exploited by the executive branch, and understandably so. The judicial branch, despite flowery rhetoric, has abdicated its responsibility for oversight, and the legislative branch has been historically silent. Fortunately, the latter situation, as evidenced by this hearing, is no longer. Let me state at the outset that I support the passage of the current language in this bill about the privilege, although admittedly any favorable substantive impact it might have is likely too difficult to measure. But the importance of the legislation is that it very clearly opens the door for the first time in history for true congressional involvement and oversight, in particular to allow for the application of the most important type of test when it comes to executive branch claims of classification. That's one of smell. I know all too well the implications of litigating cases involving national security disputes and classified information. Oftentimes my client's very identity or relationship to the United States government is a highly classified secret. I'm frequently in the trenches fighting with federal agencies concerning access to classified information. Over the years, I've handled or have been consulted on a number of SSP cases. I'm generally aware in those cases of much of the information that is classified. Sometimes I know the exact information that's classified, but other times I know little to none of what's involved. I do appreciate, and I think this is important to note, the nature of properly classified information. There are many secrets, as many of you know, that absolutely need to be protected. The disclosure of some of the information that I've been privy to over the years could easily cause serious damage to the national security interests of the U.S. and could lead to the loss of life, including that of my own clients. And I take that prospect very seriously. The problem is that excessive overclassification is rampant and at times purposefully abused. Secrecy was designed to serve as a shield to protect the disclosure of certain harmful or sensitive information. In the context of civil litigation, it is quite the opposite. There it is, the equivalent of a two-handed sword that in one fell swing, at the outset of a battle, decapitates the enemy. The sword is the privilege, and the enemy is fair judicial due process. Since the privilege was created in 1953 by the Supreme Court in United States v. Reynolds, courts routinely remind the executive branch that its assertion is not to be lightly invoked. And as routinely as that reminder occurs, the executive branch routinely ignores it. Moreover, rarely does a federal judge do anything other than accept carte blanche whatever an agency head states in a classified declaration submitted for review in camera and ex parte. There's no role based on current law for the plaintiff's attorney, even when we do have security clearances, to actually review that declaration or comment on it. Essentially, it's the defendant in the role of a batter telling the pitcher to throw the pitch that he wants to guarantee that he could hit a home run. In the majority of the privilege cases that I'm familiar with, the court never even gets to the point where the specific classified documents are in question. It is only the one-sided, self-serving, classified declaration that is reviewed and serves as the basis for the court's decision. Indeed, there's no case that I am personally aware of where the judge even verbally posed substantive questions or requested clarifying information in writing based on what was contained in the classified declaration. Yet we know from the Reynolds case that a federal agency will mislead and arguably lie to a court in order to protect itself. The misuse of the classification system, especially in the context of judicial proceedings, is destructive to the fundamental tenets of our Constitution. But the courts repeatedly hold that it is generally not within their purview to intervene on national security matters. Frankly, I reject the notion that federal judges neither have the authority nor can exercise the expertise regarding classification decisions. I'd submit that Congress agrees with me due to its role in creating such statutes as the Freedom of Information Act and the Classified Information Procedures Act, both of which allow for judges to explicitly exercise authority in the national security realm. Regrettably, in 2005-2006, the Supreme Court had an opportunity to ensure that this hearing never occurred. It had two cases pending for certiorari. It had two others pending at the Circuit Courts of Appeals and at least one other at the District Court. And in briefs that I filed, I made it very well known to the court that this was happening, that the first time in 50 years they had an opportunity to clarify the ambiguity. and in each of the cases, they declined without comment to even rule. Instead of making that decision, they didn't follow their own admonition in Reynolds that judicial control over the evidence in a case cannot be abdicated to the caprice of executive officers. To put the consequences of the privilege in some sort of understandable perspective, I find it distressing that foreign criminal terrorist defendants receive more rights to ensure that they and their counsel have access to classified information than do U.S. nationals who place their lives on the line to fight against foreign criminal terrorists. The absurdity and irony of this irreconcilable discrepancy must not go unnoticed any longer.